My wife secretly moved funds from our joint account before filing. I had already restricted transfers and alerted my attorney. The court ordered immediate reversal and penalized the action. She reached out when her strategy backfired publicly. The account shows a zero balance. That's what my attorney said to me on a Tuesday morning, calm as someone reading a grocery list, while I sat across from him in a leather chair that suddenly felt like the floor was dropping out from under it. Zero, I repeated. Not because I didn't hear him, but because my brain refused to accept a number that should have been $143,000. He slid the printed bank statement across the desk like a poker player revealing a dead hand. I picked it up, looked at the date. The transfers had started 3 weeks ago. Small ones at first, $2,000 here, $3,500 there, designed to look like routine expenses. Then larger ones, $8,000, $12,000, $19,000 in a single afternoon. All of it gone. All of it moved to an account I didn't recognize. And all of it done by my wife, the woman who had been sleeping next to me, eating dinner across from me, and asking me how my day was, while quietly draining every dollar we had built together over 11 years. Hey viewers, before we move on to the video, please make sure to subscribe to the channel and hit the like button if you want to see more stories like this. I need to give you a little context before this goes further. Not much, just enough to understand what was at stake. I'm 41 years old. I live, or I used to live, in a house in the Pacific Northwest with a wraparound porch and a yard that took me 3 summers to get right. My wife, Diane, and I had been married for 11 years. No kids. 2 careers. 1 joint account that represented everything we had worked towards since our mid-20s. That's all you really need to know right now. The morning I found out, I hadn't gone to the attorney's office expecting bad news. I had gone to drop off some paperwork. Proof of income documents. The routine kind of thing you do when a marriage starts legally dissolving and you're trying to keep everything organized and above board. My attorney, a methodical man named Hoffman who had been practicing family law for over 2 decades and had the emotional range of a traffic cone, had called me the night before and said, "Bring whatever financial statements you have from the past 60 days. I had printed them out at home, logged into the joint account, downloaded the PDF, and handed it to him the next morning without even looking at the numbers closely. He looked at them. His jaw didn't move. His expression didn't change. He just reached for the phone, called his paralegal, asked her to pull up the account activity report, and then placed the printed statement back in front of me. The account shows a zero balance. That was how my Tuesday started. Here's what I need you to understand about the weeks leading up to that morning. Diane and I had officially separated 6 weeks earlier. She had moved to her sister Renee's place about 20 minutes away. The decision had been mutual, or at least I thought it had been. There was no explosion, no screaming match that ended with someone throwing things. It was quieter than that, more clinical, like 2 people who had slowly stopped recognizing each other and finally admitted it out loud. She said she needed space. I said I understood. We agreed to work through the financial separation with as little conflict as possible. I believed her. That was my mistake. Because while I was being cooperative and reasonable and scheduling mediation sessions and forwarding her emails about division of assets, Diane had been meeting privately with her own attorney. I didn't know that yet. I would find out later that she had retained someone 3 full weeks before she told me she wanted to separate. Which means the conversation she had with me, the one where she cried and said she was exhausted and didn't know how we had gotten so far from each other, had been rehearsed. Or at the very minimum, calculated. She already knew what she was going to do. She already had a plan. And that plan involved moving the money before I could do anything to stop it. Hoffman leaned back in his chair and studied me. "Did you know she had access to the full account?" he asked. "Of course," I said. "It's a joint account. We both have full access. Did you change the transfer settings at any point after the separation?" I shook my head. He exhaled through his nose. "That's where we are then." I stared at the zeros on the statement. $143,000. Gone. Methodically. Quietly. Over the course of 3 weeks while I was being cooperative. "What do we do?" I asked. Hoffman didn't answer immediately. He pulled out a legal pad and uncapped a pen. "First," he said, "we document everything. Every transfer. Every date. Every amount. Second, we file an emergency motion. What she's done is almost certainly illegal under marital asset law, depending on how the court interprets dissipation of marital assets. Third," he paused and looked at me, "we move fast." I want to tell you something about Hoffman. He was not the kind of attorney who got excited. He wasn't the type to lean forward and say, "Oh, we've got her." He was measured and careful and spoke in complete sentences that rarely contained unnecessary words. So when he said, "This is actually a very strong position for you," I paid attention. "She made a critical error," he told me. "Moving marital funds after the legal separation date, especially in this volume and this pattern, is going to look very bad in front of a judge. Courts take this seriously. It's not just frowned upon. It changes things." "How does it change things?" "It changes the tone of the entire proceeding," he said. "Judges don't like financial manipulation during dissolution. It signals bad faith. And when someone signals bad faith this clearly, this early, it tends to color everything that follows." I sat with that for a moment. "Can we get it back?" "We can certainly try." Over the next 48 hours, Hoffman filed an emergency motion to freeze any further transfers and to compel the reversal of all funds moved after the legal separation date. He also contacted the bank directly and had them place an administrative hold on any outgoing transfers tied to the account. And then he called me that Thursday evening with something in his voice that I hadn't heard before. A slight edge, like he had found something. "I need to ask you something," he said. "Go ahead. Before you came to see me Tuesday, before you knew about the transfers, had you done anything to the account?" I paused. "Because actually, yes. About 4 weeks earlier, before the transfer started, before I had any reason to suspect anything, I had called the bank about something else entirely. There had been a charge on the account I didn't recognize. A small one. A hotel charge from a city I hadn't been to. It turned out to be a data entry error on the bank's end, which they corrected, but while I was on the phone, I had asked them about setting up alerts for large transfers. I thought it was just good financial hygiene during a separation. I had requested that any transfer over $5,000 require a secondary authorization, a text confirmation to both account holders. And I had requested email alerts for any transfer over $1,000. At the time, I hadn't even told Hoffman about it. It felt too minor to mention. "I set up transfer alerts," I told him. Silence on the other end. "When?" "About 4 weeks ago." More silence. "Did you receive any alerts?" I pulled up my email right there on the phone. I hadn't been checking the account obsessively because I trusted the separation process. But the alerts were there. Every single one. 2,000 alert. 3,500 alert. 8,000 alert. And each one of those alerts had required a secondary confirmation that I had never given. Which meant, "Hoffman," I said slowly, "does this mean what I think it means?" "It means," he said, "that she bypassed your secondary authorization on every transfer over $5,000. How? That's what we're going to find out." What we found out, through the bank's records, which were subpoenaed as part of the emergency motion, was that Diane had called the bank herself approximately 2 weeks after I set up the secondary authorization. She had told them she was having trouble receiving the confirmation texts due to a phone issue. She had gotten them to temporarily suspend the secondary authorization for her account access. She hadn't done anything technically fraudulent. She was a joint account holder, and she was who she said she was, but she had specifically worked around a security measure that I had put in place. And the timing made it obvious that she knew about the restriction. She hadn't called the bank about a general account issue. She had called about that specific feature, which meant someone had told her about it. Or she had logged into the account, seen the new settings, and taken deliberate steps to neutralize them before beginning the transfers. Either way, the intent was clear. And Hoffman was practically calm when he told me this was, in his words, a gift. "A gift," I repeated. "For our case, yes," he said. "She didn't just move money. She actively circumvented a financial safeguard. She called the bank specifically to disable a restriction you had placed. That's not impulsive behavior. That's planning. And planning makes intent obvious. Intent is exactly what a judge needs to see. When's the hearing? 10 days. 10 days. I had 10 days to sit with this. 10 days to go home to a house that still had her coffee mugs in the cabinet and her handwriting on the grocery list stuck to the refrigerator with a magnet we had bought in Portugal. 10 days to sleep in the same bed, where we had talked about retirement plans and debated paint colors for the guest room, and made all the quiet promises that people make when they think forever is a real thing. I didn't call her. I want to make that clear. In those 10 days, I did not call Diane once. Not out of spite. Not because Hoffman told me not to, though he did, but because I genuinely didn't know what I would say. I had loved this woman. I had trusted her instinctively, the way you trust the ground not to move when you step on it. And she had seen that trust and decided to use it as a runway for her escape plan. There's a particular kind of grief that comes with that realization. It isn't loud. It doesn't announce itself. It just sits in your chest like something heavy and waits for you to be still enough to feel it. I felt it at night, mostly. During the days, I stayed busy. I reorganized the paperwork. I responded to Hoffman's emails promptly. I went to the gym at 6 in the morning because physical exhaustion was the only thing that made the quiet of the house bearable. And I waited. The morning of the hearing, I drove myself. Hoffman had offered to have his paralegal meet me in the parking lot to walk me through some last-minute notes, but I told her I was fine. I sat in the car for 7 minutes before going in. Not because I was nervous exactly, more because I was trying to decide what kind of person I wanted to be that morning. Not for the judge. Not for Hoffman. For myself. I decided I wanted to be someone who stayed quiet and let the facts do the talking. That turned out to be the right call. Diane was already inside when I walked into the courtroom. She was sitting with her attorney, a woman named Voss who had a reputation in local family law circles for being aggressive. Diane looked good. That was the first thing I noticed, and I hated that I noticed it. She was wearing a dark blazer and had her hair pulled back. She looked composed. She looked ready. She glanced up when I came in. Our eyes met for maybe 2 seconds. Then she looked away. I sat down next to Hoffman. He had already arranged his documents in the order he planned to present them. He didn't look up when I sat down, just slid a notepad toward me with a handwritten note. Let me handle the questions. Don't react to anything. I nodded. The hearing began. Voss opened by framing the transfers as routine marital expense management. She used phrases like standard household liquidity adjustment and equitable predistribution of shared assets. She argued that Diane, as a joint account holder, had every legal right to access the funds. She argued that the amounts moved were within the normal range of personal financial activity. She did not address the secondary authorization bypass. She did not explain why Diane had called the bank specifically to disable that feature. I watched the judge as Voss spoke. He was in his 60s with reading glasses pushed down his nose and the kind of stillness that comes from having sat through 10,000 hearings and having long since run out of patience for performances. He let Voss finish. Then he looked at Hoffman. Counsel. Hoffman did not perform. He presented. He had a timeline printed on a single page, clean, clear, chronological. The date of legal separation. The date I called the bank to set up secondary authorization and alerts. The date Diane called the bank to have the secondary authorization suspended. The date the first large transfer occurred. The amounts. The account the funds went to, which turned out to be a new individual account opened in Diane's name only, at a different bank, 11 days after our legal separation. He presented the bank's records. He presented the email alerts I had received. He presented the subpoenaed phone records showing Diane's call to the bank. He presented the new account opening documents, obtained through legal discovery. He presented all of it quietly and without drama. And then he said, Your Honor, this is not a question of access. It's a question of intent. The respondent did not simply access a joint account. She actively identified and neutralized a safeguard put in place by the co-holder, then systematically moved the entirety of shared marital funds to a private account opened specifically for this purpose. This is dissipation of marital assets with intent to defraud. The judge looked at Voss. Counsel, do you have a response to the timeline? Voss had several responses. None of them addressed the timeline directly. The judge took about 45 minutes before coming back to the bench. 45 minutes that felt like standing underwater. I sat in a chair outside the courtroom and drank bad coffee from a paper cup and stared at a water stain on the ceiling tile across from me. Hoffman sat next to me. He didn't say much. At one point he said, The timeline was good. I said, You prepared it. He said, You kept the records. That was true. I had kept everything. Every alert email. Every bank notification. Every document. Not because I had predicted this moment, but because that was how I operated. I was a records person. And in this case, being a records person had saved me. When we went back in, the judge read his decision from notes he had written in a small, neat hand. He ordered the immediate reversal of all transferred funds back to the joint account. He ordered that the joint account be placed under court supervision for the remainder of the dissolution proceedings, with any withdrawal over $500 requiring court notification. He found Diane's actions to be in bad faith under the state's marital asset dissipation statute. And then he did something that Hoffman had indicated was possible, but that I hadn't let myself fully count on. He issued a financial penalty against Diane, assessed against her share of the final asset division. The penalty was 20% of the total dissipated amount, which, on $143,000, came to $28,600, assessed against her, from her share, immediately binding. The judge also noted that this finding of bad faith would be considered when evaluating other aspects of the dissolution, including attorney's fee assignments. He closed his folder. Court was over. I didn't feel triumphant. I want to be clear about that. I know that's what people expect, that there would be some rush of satisfaction, some sense of vindication. There wasn't. There was just a kind of exhausted clarity. Like when you've been squinting into bright light for so long that you forget what normal vision feels like. And then the light finally shifts, and you just feel the relief of seeing things the way they actually are. I had seen things the way they actually were. My wife had planned this. She had been methodical about it. She had looked at 11 years of shared life and decided the best move was to take what she could before the rules applied. And I had the paperwork to prove it. That wasn't victory. That was just the truth. Hoffman walked me to the parking lot. He shook my hand with the kind of firm grip that lawyers use when they know the work was good. What happens next? I asked. The funds transfer back within 7 business days, he said. The bank has already been notified. You'll receive a confirmation when it's complete. From here, we continue with the normal dissolution timeline. But our position is significantly stronger now. The court has already seen who is willing to act in bad faith. That matters. I nodded. Will she appeal? Voss will evaluate the options, he said. But honestly, there's not a strong basis. The evidence was clean. The timeline was airtight. If I were advising her, I would tell her to let it go and focus on negotiating the remaining asset division as favorably as possible. And if you were advising her, I said, she wouldn't have done what she did. Hoffman almost smiled. No, he said. She wouldn't have. I drove home, made dinner, ate alone, watched part of a documentary about shipwrecks that I didn't finish, went to bed. Somewhere around 2 in the morning, I woke up and lay in the dark and thought about the year Diane and I had driven up the coast for our anniversary. We had stayed in a small place on the cliffs, the kind of place with no TV and windows that let in the sound of the ocean. She had laughed so much that trip. Real laughing. The kind that makes your whole face hurt. I thought about that. I thought about the distance between that person and the person who had called the bank to disable a security feature so she could drain our shared account before I noticed. I thought about whether those were the same person or 2 different people or something more complicated than either. I didn't reach any conclusions. Eventually, I fell back asleep. The funds were restored in 6 business days. Hoffman sent me the confirmation email. I read it twice, then filed it in the same folder where I kept everything else. 2 days after that, Diane's attorney filed a formal response to the court order, disputing the penalty amount on procedural grounds. Hoffman called to let me know. Is it a serious challenge? I asked. It's a gesture, he said. It signals that she's not going to simply accept the terms, but the grounds she's citing are thin. The penalty was properly calculated, and the bad faith finding was clearly supported. I would expect the challenge to be denied. It was denied 11 days later. Now here is the part that people always want to know about. The call. Because about 3 weeks after the court ruling, after the funds had been restored, after the penalty had been upheld, after the word had gotten around in whatever circles it gets around in, when a court proceeding becomes less private than you expected, Diane called me. It was a Saturday morning. I was in the backyard working on a section of fence that had been bothering me for 2 seasons. My phone buzzed on the porch railing. Her name on the screen. I stared at it for long enough that the call almost went to voicemail. Then I picked up. Hey, she said. I said nothing. Are you there? She asked. I'm here. A pause. A long one. The kind that tells you the person on the other end rehearsed what they were going to say and then lost confidence the moment they heard your voice. I wanted to call, she said finally, because things got public in a way I didn't expect. I almost laughed. Public? People know, she said. People in my office. Renee's husband. It's been a problem. I'm not sure what you want me to do about that, I said. Another pause. I'm not asking you to do anything, she said. I wanted to explain. Diane, I said. You don't need to explain. I have all the bank records. I have the timeline. I know exactly what happened and exactly when you decided to do it. It wasn't, she stopped. It wasn't what? I asked. She was quiet for a moment. Then, very quietly, she said, I was scared. I put down the fence tool I was holding, sat on the porch step. Scared, I said. I was scared that you were going to move the money first, she said. My attorney, my original attorney, before Voss, told me that in separations like this, sometimes one partner tries to control the assets to gain leverage. And I thought, you thought I was going to do what you did, I said. Silence. Yes, she said. I breathed. In. Out. Diane, did I ever give you a single reason to think I would do that? A very long pause. No, she said. Did I, in 11 years, ever once hide money from you? Ever take anything from our shared account without telling you? Ever do anything to suggest I would use our finances as a weapon? No, she said again. So you were told a story by someone who had a financial incentive to make you afraid, I said. And instead of asking me, instead of talking to me about it, you made a plan. You opened a new account. You called the bank to disable my security settings. You moved everything. Systematically. Over 3 weeks. She didn't answer. That wasn't fear, I said. Fear is calling me. Fear is saying, I'm worried about the money. Can we talk about it? What you did wasn't fear. It was a choice. She started crying. I heard it in her breathing. The way it changed. And the terrible thing, the thing I hadn't expected, was that some part of me still responded to it. 11 years does that to you. Your nervous system doesn't just forget a person because the legal documents say they're becoming your former spouse. But I also knew that tears were not accountability. And I had learned the difference between someone who was sorry and someone who was sorry that it hadn't worked. I know you're upset, I said. I understand that this has been hard. Hard, she repeated. But I need you to hear me on this. What hurt wasn't the money. The money is coming back. What hurt was understanding what you were willing to do. Understanding that you looked at our life together and calculated how to strip it before I could respond. That's not something I can unknow. She was quiet for a while. Then she said something I hadn't expected. You already knew. Not a question. A statement. What do you mean? I asked. When I started moving the money, she said. You already knew, didn't you? You'd already told Hoffman. I didn't confirm it. But the silence was its own answer. I thought so, she said. Voss said the way Hoffman moved. The speed of the emergency motion. How prepared he was. She said it felt like you had been ready for it. I had been prepared for a lot of possibilities, I said. Not because I suspected you specifically. Because that's how I operate. You know that about me. Yeah, she said. I do. A pause. Your attorney was very good, she said. He was prepared because I gave him good records, I said. She made a small sound. Something between a laugh and a sigh. Of course you did. There was a long, quiet stretch. One of those silences that used to be comfortable. That used to mean we were just existing in the same space, not needing to fill every moment with words. Now it just felt like distance. What happens now? She asked. The dissolution continues, I said. Hoffman and Voss negotiate the remaining assets under court supervision. When that's done, we sign the papers and it's over. And the penalty? Stays, I said. It was upheld. She said nothing. The penalty isn't the point, I added. The point is that the court saw what happened. And that's part of the record now. I know, she said. Is that why you called? I asked. Because of the record? A pause. Partly, she admitted. I appreciated the honesty. It was the most honest thing she had said in a while. Voss thinks we should consider a negotiated settlement, Diane said, to avoid further litigation. Hoffman has been open to that from the beginning, I said. I have always preferred the simpler path. You know that. I know, she said. I know you have. Diane, I said. You could have called me before any of this. Before you called the bank. Before you opened the new account. Before you started moving money at 2 a.m. I paused. Yes, I know what time some of those transfers happened. I have the records. She went very quiet. You could have called me, I repeated, and said, I'm scared about the money. I need reassurance that you're not going to do something with it. And I would have said, let's put it under joint court supervision right now. Let's agree to freeze it. I would have done that. Without a lawyer. Without a fight. Because that's who I am. I know, she said. And her voice, when she said it, had something in it that was real. Not performance. Not strategy. Just the sound of someone understanding something too late. I know, she said again. We didn't talk long after that. There wasn't much left to say that wasn't going to go through attorneys eventually anyway. Before she hung up, she said, for what it's worth, I'm sorry. I thought about that word. Sorry. All the ways it can mean everything and nothing at the same time. I believe that you mean it right now, I said. I do. But, she said. But meaning it and being it are different things, I said. And what you did wasn't a mistake. It was a plan. Mistakes are things that happen in a moment. What you did took weeks. She didn't argue. That meant something. I'm not sure what. but it meant something. Take care of yourself, I said. And I hung up. The negotiated settlement took another 4 months. For months of carefully worded emails and scheduled calls between Hoffman and Voss and occasional meetings that I sat through feeling like an observer in my own life. But it moved forward. The bad faith finding had changed the terrain, just as Hoffman had said it would. Diane's position in negotiations was weaker than it would have been. Not devastatingly so. She was still entitled to what she was legally entitled to. But the penalty had come from her share, and the court's supervision of the account had prevented any further maneuvering. She had played a card early, and it had blown back on her. And so we negotiated from a position of relative clarity. I got the house. I had always wanted the house more than she did, and by the end she didn't fight it. The remaining liquid assets were split according to the court's formula, which accounted for the penalty. We divided the retirement accounts through the proper legal channels. It was not clean exactly, but it was resolved. The papers were signed on a Wednesday afternoon. I sat in Hoffman's office and signed my name in several places and watched the notary stamp each page, and that was 11 years. That was the coffee mugs in the cabinet and the yard I had spent 3 summers on, and the road trip up the coast, where she laughed so hard her face hurt. 11 years. Reduced to ink on paper and a notary stamp. I drove home, stood in the driveway for a minute, looked at the house, the wraparound porch, the yard. Still mine. Still here. I went inside. A few weeks later, my friend Qley came over. We had been friends since college. He was one of the few people who knew the full story, not from social media speculation or secondhand accounts, but because I had actually told him. We were sitting on the back porch with beers watching the last light go out of the sky. "Can I ask you something?" he said. "Sure." When she called, the call after the ruling, what was that actually like? I thought about it. Strange, I said. Strange how? Strange because part of me still recognized her. I said, you spend 11 years with someone and your nervous system doesn't just forget. You hear their voice and there's still a response. A familiarity. And that's uncomfortable. When you've learned that you can't trust someone, but your body still responds to them like you can. Qley nodded. Did you want her to call? No, I said. Did you want her not to call? I considered that. I didn't know until after, I said. When I hung up, I felt clear. Like something had been said that needed to be said. Not for her sake. For mine. What did you say? I told her that what she did wasn't fear, I said. It was a choice. Qley was quiet. What did she say? She said she knew. Something changed after the papers were signed. Not dramatically. Not in any way I could point to exactly. But the weight shifted. The house felt different, still mine, but differently mine. Like it was becoming something new rather than just being what it had been with half of it missing. I repainted the guest room. Took out the old wooden shelf in the kitchen that had been bothering me for years, but that Diane had liked. Bought a new coffee maker. Small things. The kind of small things that tell you, quietly, that you are the only one making decisions now. And that is not only a loss. It is also something else. I thought a lot about the bank call. Not Diane's call. The one where she disabled the secondary authorization. My call. The one where I set it up. I thought about how I had made that call for such a mundane reason. A billing error. An unrecognized charge. And how asking one sensible question during a routine call had, 4 weeks later, become the thing that changed the outcome of an entire legal proceeding. I didn't take credit for being clever. I hadn't been clever. I had just been careful. The way I always am. The way Diane always knew I was. She knew I kept records. She knew I tracked things. And she still thought she could move $143,000 without me noticing. That told me something. It told me that even after 11 years, she had underestimated me. Or maybe she had been so focused on her plan that she'd stopped thinking about who she was dealing with. Months later, not many, but some, I ran into someone who knew Diane through the professional circles she moved in. A woman named Petra who worked in an adjacent field. We had met at a conference a few years back and had the kind of casual acquaintance that lives entirely in polite small talk. She came up to me at a work event. I heard things got complicated, she said, which was the polite way people said what they actually meant. They worked out, I said. I heard she called you, Petra said. I looked at her. People talk, she said. I'm sorry if that's uncomfortable. It's fine, I said. She was embarrassed, Petra said. More than she expected to be. When the court order became part of the public record, divorce proceedings are public unless sealed. It was available. And people looked. I know, I said. I'm not telling you this to pile on, Petra said. I think you handled it better than she expected. What do you mean? She expected a fight, Petrus said. She expected you to go loud, make accusations, get emotional, make it messy, and instead you just had the paperwork. Hoffman just had the timeline, and it was over before it really started. I thought about that. I wasn't trying to outmaneuver her, I said. I was just being myself. Petrus smiled. I know, she said. That's what made it so effective. I don't think about Diane every day anymore. There was a period, longer than I expected, where she was still the first thought I had in the morning. Not out of longing exactly. More the way your mind returns to an unresolved problem. Trying to work it out. Trying to understand how someone you knew so well could have become so unfamiliar. But that period passed. The way things do. Slowly, and then more quickly. I had a conversation with Hoffman a few months after everything was finalized. I was following up on some administrative detail about the finalized records, and at the end of the call, without really planning to, I asked him something. In your experience, I said, how often does it go like this? The person who tries to get ahead of the process ends up worse off. He thought about it. More often than they expect, he said. People assume that moving first gives them an advantage. And in some situations, it does. But in family law, under court supervision, with discovery and subpoenas available, the evidence almost always catches up. What matters isn't who moves first. It's who has the cleaner record. And we had the cleaner record. You had an impeccable record, he said. You had alerts you hadn't even realized were going to be relevant. You had a secondary authorization system. You had every email dated and filed. You came to me with documentation that I would have spent weeks requesting, and you just had it. In a folder. I was quiet for a moment. I've always kept good records, I said. Yes, he said. You have. There's something I want to say about the whole experience. Not a lesson exactly. I don't like reducing a decade plus of a person's life to a lesson. But something. What I learned. Or maybe what the experience confirmed. Is that the way you operate in ordinary times is the thing that protects you in extraordinary ones. I didn't set up those bank alerts because I was suspicious of Diane. I set them up because that's how I handle things. I kept records of everything not because I was building a case, but because that's how I've always operated. And when everything fell apart, when the floor dropped out on a Tuesday morning in Hoffman's office, the foundation was already there. Not built for the crisis. Just there. Because I had always built it. The wraparound porch still looks exactly the way it did the day we bought the house. The yard took me 3 summers to get right. Both of those things are still true. The house is different now, quieter in certain ways, louder in others. Some mornings, especially in the early season when the light comes through the back windows at a particular angle, I feel the weight of what used to be here. It doesn't last long, but I let it be there when it comes. Because that seems right. You don't get 11 years back. You don't unlearn a person. You just carry it differently over time. You put it in a folder, you file it correctly, and you keep moving forward. Cole asks me sometimes if I'm doing okay. The way he asks it, casually, not making it a whole thing, is one of the reasons we've been friends for as long as we have. I'm good, I tell him. And most of the time, that's actually true. Not performed. Not a brave face. Just genuinely, carefully, one day at a time true. The house looks good, he said the last time he came over. I repainted the guest room, I said. I noticed, he said. Good color. I picked it myself. I know, he said. And we sat on the back porch and watched the sky do what it does. And that was enough. If there's one thing I'd want anyone to take from this, one thing that's actually practical and not sentimental, it's this. Pay attention to your accounts. Not because you should be suspicious of everyone you love, but because clarity, in the form of records and documentation and security features, is not hostility. It's not a statement about the other person. It's just a way of moving through the world that protects you when things change. And things always change. Marriages end. Relationships shift. People make choices that surprise you. The documentation isn't preparing for failure. The documentation is just what it is. Facts, dates, amounts, timestamps. And sometimes, not always, but sometimes, those records become the thing that keeps you standing when someone else has decided the floor is theirs to take. Diane hasn't reached out since that Saturday morning phone call. I haven't reached out to her. That's the appropriate distance. The legal dissolution is complete. The court records are sealed where they can be. What remains is just 2 people who used to be one legal unit, now separate and moving in different directions. I hope she's okay. That's not performance either. I genuinely hope she finds whatever she was looking for when she made the plan. I hope it was worth the cost. I hope she understands now that there would have been an easier way. but I can't control what she understands. I never could. That might have been part of the problem. The settlement check cleared. The retirement accounts transferred. The house is in my name alone. The joint account was closed by mutual agreement as part of the final terms. Everything is accounted for. Everything is filed. The folder is thick. And the yard still looks good. That's not a metaphor. The yard actually looks good. I spent most of last weekend out there. The light was right. The air was still. And I had nowhere to be except exactly where I was. Some nights I still wake up at 2 in the morning. Not because I'm thinking about her. Not because I'm thinking about the money or the court order or the phone call or any of it. Just because that's what my body does sometimes. I lie in the dark. Listen to the house settle. Think about nothing in particular. And then I go back to sleep. In the morning I make coffee in the new coffee maker. I check my email. I look at my accounts, the individual ones, the ones with my name only, with the alerts still set up. And then I go on with my day. Careful. Documented. Clear.